This is a dictation on special leave petition. Get ready for a dictation. 5 seconds. Start. A special leave petition means when an individual takes special permission to be heard in an appeal against any high court, bar, tribunal verdict. It is a petition for an appeal. After filing SLP, the Supreme Court hears the matter, and if it is fit, then leave is the grant, and thus convert that petition to an appeal. After an appeal and hearing of the matter, the court passes a judgment. It can be filed against any judgment of a high court within 90 days from the date of judgment, and it can also be filed within 60 days against the order of a high court refusing to grant the certificate of fitness for appeal to the Supreme Court. An untrue averment regarding material statements or a false statement on a matter of importance or a deliberate untrue statement regarding valuation has been made to mislead the court, then the special leave grant can be revoked. The mistake was not deliberate, as the special leave petition was drafted based on the valuation given in the judgment of the High Court itself, which was corrected long afterward. The petitioner's senior counsel before the High Court made certain concessions and further did not press the grounds in the application. The filing of the special leave petition without disclosure of the fact would amount to suppression of facts and would disentitle the petitioner from receiving relief under Article 136 of the Constitution. The court provided some of the principles governing interference by the Supreme Court in criminal appeals by special leave. The court would not interfere with the concurrent finding of fact based on pure appreciation of evidence, even if it were to take a different view on the evidence. The court will not normally enter into a reappraisal or review of the evidence unless the assessment of the High Court is vitiated by an error of law or procedure, or is based on an error of record, misreading of the evidence, or is inconsistent with the evidence, where the evidence is inconsistent with the medical evidence. The court would not enter into the credibility of the evidence with a view to substantiating its own opinion for that of the High Court. The court would interfere where the High Court has arrived at a finding of fact in disregard of the judicial process, principles of natural justice or fair hearing, or has acted in violation of a mandatory provision of law or procedure, resulting in serious prejudice or injustice to the accused. The court might also interfere where, on the proved facts, wrong inferences of law have been drawn, or where the conclusions of the High Court are manifestly perverse and based on no evidence. There are two types of special leave petitions. One is special leave petition civil, the second is special leave petition criminal. That's all.